we saw regarding law related to patents, and then devices, images of animals, images of people, all of that. It's a combined, a combination of all of that is called a trademark. Now we also saw examples of Apple. We saw Apple, we saw Puma, we saw Adidas as examples. It is something that they use to market the goods. And whoever has registered that particular symbol will have the entire right over that particular mark. Now they have the right of registering their mark, and if it is registered, then will go. One second, let me just. Our symbol is there on the name, that means it's a registered trademark. And if TM, you can see, that means it is an unregistered trademark, but they have applied for the registration. So the registered trademark is for 7 years. It's for 7 years, and they have to keep renewing it for an indefinitely period. Again, we also saw that the owner, whoever has got the particular, whoever has registered the particular trademark has got the entire right to distinguish the product from other people's products and services. So that's why the trademark is in use. Let's move ahead. Now, the functions of the trademark: it is used to advertise goods. It is used to identify the goods and services. It guarantees its unchanged quality, and it creates an image for goods and services. Now, when you talk about advertises goods and services, means when you talk about advertise goods and services, it's nothing but with the particular trademark, you can advertise your products. For example, Puma, Adidas. Looking at the trademark, looking at the symbol, you know that it is. If you just look at the tick mark, you know it is a say Puma or an Adidas one. So now it identifies the goods or services. Now, as I said, if anybody just looks at the symbol, looks at the Apple symbol, you know it's an iPad, you know it's an iPhone, you know it's an iPod. It guarantees the unchanged quality. If it is an iPad, if you see an Apple symbol, you know that it's an Apple company's product, so you know how good the quality is. So, and if it's a fake product, you know the quality is not going to be good. But so if it's an iPad and if there's an Apple symbol, you know how good the quality will be. It creates an image for goods and services. So basically, so now if you see, say even if an iPhone is like 70,000-80,000 or close to an lakh, also people kind of buy it because they know an image is created for an iPhone. So those are the functions of a trademark. Now, what is a trademark? We saw that a trademark is a visual symbol which may be a word, signature, name, device, label, numericals, combination of colors, all of that put together, it is a trademark. Simple example: Apple, Adidas, Puma, and any other brand that you can think of. Say you have Reliance Trends, you have Shopper Stop, you have Lifestyle. Everybody has got their own brand, and everybody has registered their own brand. When you talk about signatures, you have signatures of Virat Kohli, you have signatures of Amitabh Bachchan that have been registered as a trademark because they don't want anyone else to use that particular symbol, their signature, as because it's their signature, it's their autograph, so they have taken a registration for their signature also. Now, the essential requirements to register a trademark: the selected mark should be capable of being represented graphically. So that means basically you need to write it, you need to draw it. If it's an image, you should be able to draw the image. Or if it's say writing like home center, it needs to be written. It should be capable of distinguish the goods or services from one undertaking from those of another. Now, if you look at say an apparel company, if you look at Reliance Trends, You have Reliance Trends, they have a particular symbol. Then if you look at Lifestyle, they have their particular symbol. If you look at Shoppers Stop, they have their symbol. Westside, they have their symbol. So basically, a particular trademark should distinguish from one company to another company's product. So that's why your trademark isn't there in the market. So if you register your trademark, you can distinguish goods from one company to another company. It should be used or proposed to be used in relation of goods or services for the purpose of indicating as to indicate a connection in the course of trade between the goods and the services, and some person may have the right to use the mark with or without identity of that person. So basically you need to use the trademark whenever you trade in that particular goods. So if say lifestyle brand, you're using lifestyle brand for apparel, so whenever all your invoices, all your clothing, everything will have a lifestyle trademark symbol. So that's what when they talk about it has to have a connection between trade and services. That's what it means. You have to use it in your trade and services. Yeah. Okay, so anybody's got any doubt till now? Anyone's got any doubt? Yes, no? Anybody's there? No one's there in class?
No doubts, ma'am.
Okay. Okay. So next, coming to what's a collective mark, is a collective mark is a trademark distinguish the goods or services of members of an association of persons, and the mark is being registered. So basically a group of people or a company or an association, say a group of people have joined together and they have registered for a trademark. That's called a collective mark. Now, a well-known trademark in relation to any goods and services means a mark which has become so to the substantial segment of the public which uses such good or services such that the use of such mark in relation to other goods or services likely to be indicating a connection in the code of rendering services between those goods and services and a person using mark in relation of the first mentioned goods or services. So basically this is about a collective mark. Collective mark is something that everybody recognizes a particular mark for a group, like say a coffee powder or a tea powder. There are many farmers, many plantation people who have those plantations. They all come together and they register their trademark. So that's called a collective mark. Now, you have definitions of mark, assignment, descriptive, similarity, and package. Mark is nothing but, as I said, a device, a brand, heading, label, ticket, name, signature, word, letter, numerical, shape of goods, all of that. Combination of all of that is called a mark. Assignment is sometimes what happens is, say if you are a Reliance Trends and you are asking someone to manufacture your apparel, say you're manufacturing kurtas, so you tell the factory that has been manufactured by someone else. So you tell the factory, see, you manufacture and you can use the brand name called Reliance Trends. So on all the dresses or all the kurtas, you print a label called Reliance Trends. Now that's called an assignment. So your assignment means you're giving permission to another person to use your trademark for a particular work. So the person should use the trademark only for that particular work and you can't use it for anything else. So other than that particular work, you can't use the symbol for any other purposes. So that's called an assignment. Now, when an assignment is done, the person pays an amount. That will be like a license fee. It will be valid only for a few years, or say 5 years, 7 years. After which, if it is not renewed, it will get cancelled. So the person cannot use the symbol again. Descriptively similar means it is not same items, but it's something like the particular trademark. Now, an apple with a leaf. Now, what if someone comes with, an apple with a leaf is like a half-eaten apple. That's an apple company symbol. Now, what if someone comes with a full apple? That is nothing but it's a descriptively similar kind of a symbol. So if someone looks at an apple, the first thing that they come into a mind was, okay, an iPad, an iPhone. But what if someone comes out with a full apple? Now, is that, though it is an apple, it's half bitten apple and it's a full apple, people might get confused. So those kind of marks will not be approved. Package. Package means any case or box, container, covering, folder, wrapper, label, ticket, reel, frame, capsule, cap lid, stopper, cork. Now, package is nothing but something that you close on. On all of that, you can add your trademark on any particular. So, this is the definition of what a package means. Now, who can apply for a trademark and how? Any person claiming to be the proprietor of the trademark used or proposed to be used by him may apply in writing in prescribed manner for registration. Now, the application should contain the trademark, the goods, services, the address, name and address of the applicant, the agent with power of attorney, the period of use of the mark. Now, who is a proprietor? Is someone who is an owner of a company. Now, that person, so a trademark is something, even before it is in use, you can register your particular trademark. So, you don't have to, now if I start opening a company and I make a mark, I make a particular trademark and I go and register saying that I am registering this trademark, and in future when I'm going to start selling goods, I will be using this mark as my company logo. So then what happens is before you start your company, before you start your products, you can register, or you can start your company, start getting your names, and then you can register the trademark. That is also possible. So there are two ways. Now, in a patent, we saw that only after manufacturing you can register for patent. But trademark, you can do it before you start using it, or you can do it afterwards. That's for a trademark. Now, an application will have to be filed. You will have to give it to the front office counter or the respective trademark offices. Now, it can be done online also. You will have to give the symbol, the trademark symbol, the colors, what all colors, whether it's black and white colors, what colors it is, whether it's red, blue, green, you'll have to mention all that. What does it indicate? What type of goods and services that is indicate is very important. Name and address of the person who's applying for it. And if the person cannot apply on behalf, he appoints an agent. So that will also have to be mentioned. Okay, anybody's got any doubts so far? Any queries? Anybody? Okay, let's move ahead. What are the different types of trademarks that may be registered in India? So we saw what is a trademark. Now, what are the types of trademark? Any name, including personal surname of the applicant or dissenter in business, or the signature of a person, which is not unusual for trade to adopt as a mark. Now, any name, so you can use anything. Reliance Trends, Lifestyle, Aspar, Home Center, or Big Basket, Big Bazaar, they are all registered trademarks. So it's a name. An invented word or any arbitrary dictionary word not being directly descriptive of the character or quality of goods and services. Now, you can't have a trademark in the name of beautiful, because beautiful, it is not an inventive word. You have not invented it, and beautiful is a description. So you can't have the term beautiful as a trademark. It needs to be any terminology which has been invented, like say Flipkart or Walmart or Microsoft. Now, those are all invented words. Letters or numericals or any combination thereof. Now you have various say apartments where you have abode 99, Concord abode 99. You will have again one more say Prestige 99 acres, something like that. They'll have certain uh, names as well as they will have numerics also. So any combination of both is also possible for registering a trademark. The right to proprietorship of a trademark may be acquired by either registration under the Act or by use in relation to a particular good or services. Now, whoever is doing it, they will have to register it under the Act, and it needs to relate to the particular goods or services that they are registering. And under that trade, so there are various trademark chapters. So you will have to go to that chapter and you'll have to register. Now, for example, Ginger. Ginger is a brand. It's an apparel brand. So that Ginger is registered in apparel. Say in future they want to come up with any cosmetics, beauty products. So it will be done in shampoos, soaps, perfumes, deodorants, all of that. Trademarks you'll have to separately register for everything. So there are various chapters. Under most of the chapters, you have to go and register it yourself. Devices, including fancy devices or symbols. Now, sometimes you see very fancy symbols with just symbols, and looking at the symbols, you are able to know what the particular brand is. Monograms, combination of colors or even a single color. Now, again, different type of colors or just shapes of the goods or their packaging, marks constituting three-dimensional sign. So like an Adidas or say a Puma's got a tick, Apple has got a half beat in Apple, Microsoft, colorful symbols. Then you have an IBM, you have Infosys. Sound marks which represent the conventional notion or description in words by being graphically represented. Now, sometimes you have words which sounds like a company's name. So that kind of a symbol, that kind of a description also is allowed for trademarks. Now, there is an application process in page 473. Okay, there is an application process. It talks about pre-examination process, it talks about examination, it talks about post-examination, and then post-advertising process, opposition, and post-registration trademark management. Now, basically, like a patent also, you do have examination which will happen, pre-examination. Then afterwards, they will go, they will they will kind of publish it in their trademark journal, and in case anybody has got any objections, they have to object it. Then you have the post-examination process. Then you will have an opposition. Say in case if someone opposes, then the reason for opposition from both the parties will be heard. So the entire process is there in page number 473. So it's a detailed process. It is something like the patent, so you can go through that. It's in simple terminology. Now, what are the benefits of registering a trademark? Now, we saw patents have to be registered, and then you get benefits for suing. You can sue anybody, you can file a case on anybody. Similar thing is for the trademark also. Now, you need to register your trademark. Otherwise, people will not know that your particular symbol has been registered. Now, multiple times, the registered trademarks also, some people will use it to sell. I think last time I told you all about what Lifestyle does for home center symbols, for Macs, what happens if someone uses it. So a notice will be given, and then they will remove it immediately. They will remove it from their board immediately. So that is something that is a benefit of having a registered trademark. Now, the registration of a trademark confirms upon the owner to exclusive right to the use of the trademark. So if you have registered your trademark, you have the exclusive use of that particular trademark. As I told you, R symbol, when you see an R on a circle, in a circle, that means it is a registered trademark. And then if it is a TM, that means this particular trademark has been registered, but application has been put, but it is still not registered. That's what it means. The TM symbol means. Now you need to register your trademark, because if in future someone uses it, the person can have a right to sue the person. So if someone else uses it, you can file a case on them, and you can claim compensation. Okay. Okay, now what they also say is, in case if you have registered in a particular area of use, means if lifestyle is registered for apparel. Apparel is nothing but clothing. So if lifestyle is registered, that particular symbol in the clothing area, say tomorrow if someone comes and uses the term lifestyle, say, but for what do you say, for buildings. I mean buildings, as in for home decor items. Then can lifestyle file a case? No, lifestyle cannot file a case, because lifestyle has registered the symbol for apparel use only. So they will only use it for clothing. But if someone else comes with lifestyle, with the term lifestyle as a brand, and selling home decor items, then they can use it. But in future, this home decor lifestyle cannot sell apparel, and lifestyle cannot sell home decor. So basically, both the symbols should be used for their particular limited use only. Now, say for example, fresh to home. Fresh to home is an item that sells, say, fish, meat, eggs, all of that. And then slowly they have started using it for vegetables, for fruits, all of that. Now, say tomorrow, if fresh to home wants to start doing a Swiggy business, say from hotel to do it, no, they cannot do it, because their symbol is registered only for food, for meat, that kind of delivery service only, not from a hotel to user delivery service. Now, there are few grounds for refusal for registration. Now, what is the absolute grounds? Yeah, what is the absolute grounds? 1 second. Grounds of refusal for registration. Now, what happens is, when the particular registration will not be accepted. A, which are devoid of any distinguished character, not capable of distinguish the goods or services from one person to another person. Now, say we come up with a symbol, something similar to Apple. But instead of 1/4 bitten apple, we do a full apple. Then will that be approved? No, it will not be approved, because that particular symbol has already been registered. Now, just because it is hidden and you are giving a full apple, it can confuse the people. So that's why that full apple will not be given as registered trademark, because it can devoid somebody, and it can create a confusion between one person and another person, which consists exclusively of mark indications which may serve instead to designate the kind, quality, quantity, intended purpose, geographical origin, or time of production of the goods, or rendering the services and other characteristics of the goods or services. Now, what happens is, sometimes many of them will use the term India, or say Karnataka, or say Bangalore, or Kerala. You cannot register those particular marks, because they are geographical in nature, geographical origin. You cannot register those kind of marks. And then quantity, quality, all that, you cannot have those as registered trademarks, which consist exclusively of marks or indications which have become customary in current language or in bona fide and established practices of trade shall not be registered. Now, way back, say a long time back, say olden days, people used to use the particular terminology, or they used to use the particular method. Now we saw in patent that you cannot register it. Now in a trademark also, if it is called by a particular name, you can't register that as a trademark also. They have that restrictions. One second. They have those restrictions also, that if it was used before in a particular customary practice or in a particular language, you cannot use that terminology as a trademark. If the trademark tends to deceive the public or causes any confusion, as I said, Apple will cause any confusion, so you cannot register it. In any trademark hurts religious sentiments, now you cannot have, say, a symbol, an Om symbol or a Shiva symbol as a trademark. That cannot be taken up as a trademark. Or any geographical section. So again, as I said, Bangalore, Kerala, India, all that cannot be registered as trademark. It comprises or contains scandalous or obscene matter. Now, if it is a scandalous or obscene particular matter, you cannot register that as a trademark. Its use is prohibited under the emblems and names prevention of improper use. So basically, as I said, India, in India, you can't register your trademark with the term India. Then you cannot use, say the Ashoka statue or the chakra. All that cannot be a part of a registered trademark, because all that will come under emblems and names under the Prevention of Improper Use Act. Okay, anybody has got any doubt? Anyone's got doubt? Yes, no, people? No, ma'am.
No, ma'am.
Let's advance. Okay. Now limitations as to color. Now again, just one second. Okay. Now limitation as to color. Sometimes you have different colors for the symbol. Now if you are registering in the particular color, that color only will be considered for your trademark. Now again, you have light, dark and all that. So basically whenever companies register it, you register it for most of the colors, because on your letterhead you might have black and white, you might have a little color, on your symbols you might have full color. So basically companies, what they do is they tend to register in on all of the colors. Now what happens if you do not register it with a particular color? That means when you are registering, it is assumed that all the colors have been registered for that particular symbol. One second. representation of living persons or persons recently dead. You cannot use those person as the name as part of a registration. I mean, for a trademark registration. Now you cannot have you cannot have say Gandhi. You can't have Indira Gandhi. You can't have someone a trademark called Rajiv Gandhi. You can't have a trademark of say Narendra Modi or Abdul Kalam. You cannot have all those names as a trademark name. They have certain restrictions that you cannot use people who've died, or say even you can't use my name as a trademark, or my symbol can be used, but my signature can be used, but not my name. As in a famous person's name cannot be registered. Even my name also cannot be registered until it is associated with a particular product. Withdrawal of application. Now, whenever say an application is made, people who are making the application has a right to withdraw the application. Withdraw the acceptance. So basically, when an application is made by mistake, or say they have made an application and then they realize that they shouldn't have made an application, and they take it back. So that way they take back the application. So it doesn't go forward after you have submitted all your documentation. Now, advertisement of application. So as I said, whenever you submit your details, they will advertise your application for any objections, and then once the objections come, the people have an if there is an objection, they will check, they will compare the marks and trademarks, and they will see when who has used it for a maximum period of time, who has to be given, who has got the right to use the trademark. Both the parties will get an opportunity to be heard, and one particular trademark will get cancelled. So that's the benefit of an advertisement of application. So they have a trademark journal where they publish all the information of the recently registered trademarks. So if anybody's got any objection, you can look at the trademark journal and you can apply for the objection. So can the registered trademark be removed from the register? It can be removed on application to the registrar on a prescribed form. On the ground that the mark is wrongly remaining on the register can also sue motu, issue notice for removal of registered trademark. So basically, you can remove the trademark from the registrar by making an application. You can remove the trademark from the list of trademark from the registrar. Now, sometimes when the registrar thinks that this trademark is no longer in use, it's not there in the business, or no one is using it, or no one has renewed the particular trademark after 7 years, then what happens is the registrar itself will remove the particular trademark from the register. Infringement of registered trademark. Now, what is the meaning of infringement? Now, infringement means I have registered a trademark and someone else is using the mark. Okay, so first thing is someone is using the mark. Second one, someone is using a similar kind of a mark, like say like a lifestyle symbol. Someone is registered the lifestyle symbol with different colors, with different outlines, and they are using it. So that is an infringement of a registered trademark. So you are going against. You do not have the right to use the trademark. You do not have the right to sell your goods with the trademark, but still you are selling your goods. Now that's called an infringement. Now, a person shall be deemed to have infringed a trademark if he uses the mark which is identical with or similar to the registered trademark. As I said, if someone uses a registered trademark, it is invalid. Okay, so basically he is using the particular trademark for his advantage, and basically a trademark speaks the quality. So if someone looks at the trademark and buys it, they will think, oh, is, say for example, an iPad. Now you look at an iPad, you look at a symbol and say, oh, this is an iPad, oh, this is an iPhone. But then actually speaking, it is not an Apple iPhone. It's just some other brand who's using the iPhone symbol, cheating the public and using an iPhone's Apple symbol. Those kind of instances is called an infringement. Now, what happens in an infringement? What happens in an infringement is you have two kind of remedies. Remedies is nothing but if someone gets to know that the particular mark has been used for benefit. Okay, so simple example, say a Puma symbol. You've seen many of say clothing and all that, they kind of have replicated like a GAP. You also have seen Puma, Adidas. So now many of them cannot afford a real Puma, Adidas or a GAP shirt. So then there are people who kind of sell a duplicate version, say not the same quality but a different quality for a cheaper price. Say it'll be written Adidas symbol will be there, Puma symbol will be there, or a GAP symbol will be there. What happens then? Basically, whoever's making them are infringing it. Now tomorrow, if an Adidas officer gets to know that shirts are being sold, and he will find out who sells those shirts, and he can file a case on these particular the manufacturing company. What happens when he files a case on the manufacturing company? He can ask for compensation. He can ask for for defamation, for people have cheated him. He has cheated people. Compensation can be asked. Any monetary loss that the person has gained, that compensation also he can ask. Basically, infringement is a technical terminology for someone cheating and using the mark. Any doubts? Anybody? Collective marks, as I said, a group of people joined together applying for a mark is called a collective mark. Now, passing off. The act or an instant falsely representing one's own product as that of another in an attempt to deceive the potential buyer. Passing off is actionable in tort under the law of unfair competition. It may be actionable as a trademark infringement. Now, as I said, particular you are using an Adidas or a Puma on your shirts, and you're trying to cheat the customer saying that it is a Puma shirt or it's an Adidas shirt. Now it is not an Adidas shirt, it's not a Puma shirt, but you are cheating the customers and you're trying to sell the product. Now that happens, that is called a passing off, and that is an actionable as a trademark infringement. So the terminology is passing off. Now what happens then is you again file a notice, you send them a notice, you file a case against them and ask them to remove all the shirts or all the products that they have sold. They have to take back all from the market and they must not sell it to anybody else. So there is this particular law called law of torts. So as per law of torts, it is the terminology passing off comes in law of torts. So it is not a general law that has been used, but it is a law that has been studied. Now, the competitors or other traders tend to imitate well-known or reputed trademarks by imitating color schemes or get-up or packaging with the view of passing off such goods as goods of a genuine owner. In cases of unregistered trademark, the owner can move the code under this act for infringement, whereas the cases of unregistered trademark, the act recognizes the common law remedy of passing off. Now, what happens is when someone cheats, say if a particular trademark is in blue color and they kind of now Big Basket is green color, what if someone sells Big Basket products in blue color or in red color? what happens then? Now they are cheating the customers. They are trying to tell customers, see, I am also a big basket. I'm all, my quality is also good. They are trying to use the big basket benefit. What happens then is, even if you are registered, you can go to court, but if you are unregistered, you can still file a case. Now, if Big Basket has not registered the symbol in the trademark registry, they can still go ahead and file a case saying that we have been using our symbol for so many years. Someone else has come and cheated and trying to cheat the customers. Now, we saw in patent, until the patent has been registered, you can't file a case. But in a trademark, even an unregistered trademark can also be considered in the court, and that will be basically passing off. Is even if it is an unregistered in trademark, you can still file a case against the particular person who's cheating customers. And best example is, say, a Big Basket or somebody who has not registered their symbol, but still they are well known for their trademark in the business. Okay, anybody's got any doubt? In case of the trademark, as I said before, in case of the trademark is not used for many years, if it has not been renewed, so we saw it is 7 years, and after every years you need to register, renew your trademark. So what happens if you don't renew it? Your trademark can be used by anybody, and then in case if you do not use it, so you have registered your trademark but you have not used it in your products, you are not selling your products using that trademark, what happens then is the registrar will remove the trademarks from the list of trademarks. So basically your symbol, whatever money you have paid, it'll even if you've renewed it from time to time and you're still not using it, it will be removed from the trademark registry. Trademark agent. Now we saw who is a patent agent. Now a similar agent is a trademark agent. You have a particular exam for a trademark agent. Now that person can study and apply as a trademark agent. Now what does a trademark agent do? He helps you to apply. So basically, like a patent agent or trademark agent, also you have to write an exam, pass, and register your name as a trademark agent. Now, what are the benefits? You can apply for trademarks on behalf of people. The documentations which are to be required, you can do it, because if I want to register a trademark, I can't do it myself. I need to approach a trademark agent. So a trademark agent is a person. Who is that? Now it can be a legal practitioner. It can be any particular say. Yeah, it can be a legal person. It can be a person who is registered as a trademark agent, or it can be a sole employee, regular employee who knows the knowledge about trademark. So if you know how to apply for a trademark, you can go ahead and apply for a trademark, but you need to have the knowledge about how to apply for a trademark. Okay, we are done with trademark.